This Honorable Court of Criminal Appeals of Tennessee is now in session.
We are continuing the February docket of the Court of Criminal Appeals Western Section with the panel consisting of Judge Camille McMullen from Memphis, Judge Ross Dyer from Memphis, and I'm Kelly Thomas from Maryville. 20 minutes aside. If the appellant wishes to reserve some rebuttal time, please tell me when you begin your argument. We appreciate the assistance of our Supreme Court clerk, Mr. Hivner, and Mr. Nick Morgan. There's a lot that goes on behind the scenes to make this possible. Otherwise, it would not be happening, and so we appreciate that. Call the next case, please.
State of Tennessee versus David Thomas Tidwell.
All right, on behalf of the appellant.
Good afternoon, Your Honor. My name is Jim Powell. May it please the court, I'm a member of the O'Brien and Weakley County Bars. I'm here today to represent David Tidwell, the appellant in this matter. I would like to reserve 5 minutes for rebuttal, if I might.
You may.
The first issue that we have today, Your Honor, in this, and I'll get right into the issues, is whether the court erred by allowing certain testimony during the sentencing hearing, regardless of the effect that prior incidences may have had on the victim's children, which was not a part of this case. In this particular case, the court allowed testimony regarding the victim's minor son, Trent, and about his learning disabilities, and the state insinuated in some way that the incident that the defendant or that the appellant was found guilty of contributed to this effect. It was objected to multiple times during the sentencing hearing, and as it was irrelevant and quite frankly quite a bit of hearsay involved in this, Your Honor, but the court allowed some of this testimony to get in. And while we understand that the testimony was heard only by the judge, he did allow part of it and even mentioned it in some of the records during the sentencing hearing. We believe that should not have been heard. We believe that it was highly prejudicial, unfairly prejudicial, and that it was only used for the intent of inflaming the court's ire in sentencing the appellant, Your Honor. The second issue that we have today, Your Honor, is whether the trial court erred by finding that enhancing factor 9 was applicable. In the sentencing hearing, the court found that enhancing factor 9 was that it was committed, possessed or used a deadly weapon when committing this particular crime. But in the case at hand, Your Honor, the case itself he was found guilty of misdemeanor reckless endangerment. By statute alone, 39-13-103A provides that a person commits an offense who recklessly engages in conduct that places another person in imminent danger of death or serious bodily injury. That's a Class A misdemeanor. However, reckless endangerment committed with a deadly weapon is a Class E felony. It's our position with the court today that because he was found guilty of misdemeanor reckless endangerment by the very nature of the offense alone, that the enhancing factor was improper because they used an enhancing factor. The court used an enhancing factor that, quite frankly, was not part of the offense. Had he have used a deadly weapon, it would have been incumbent on the court. The court would have found that he would have been guilty of felony reckless endangerment. The jury would have found that rather than misdemeanor reckless endangerment. So we don't believe that it was proper to use that enhancing factor when sentencing the defendant here, appellant. Therefore, it says the wrongful application. I apologize, Your Honor. I lost my place here. This is new to me as it is to y'all, I'm sure, and it's a little bit confusing. But anyway, going forward, that would be our position on that. Our next issue is the trial court in sentencing the appellant found that enhancement factor 10 was applicable, which states essentially that the appellant did not hesitate to commit a crime where the risk to human life was high. During the motion for a new trial, the court found that it had improperly used that enhancement factor, that it was not correct and the court should not have used that. However, they did not do anything to reconcile that. They did not reduce the appellant's sentence by any means or put him on some kind of alternative sentencing. While we understand that misdemeanor sentences, he could have sentenced him anywhere from 0 to 11 months and 29 days of incarceration. The fact that he used the enhancement factor would indicate that he increased the appellant's sentence because of the enhancement factor. We submit to the court that when the trial court found that that was not appropriate, they should have reduced his sentence in some way, or reduced the seriousness of it in some way, or even given him alternative sentencing. By the court saying that it found the enhancement factor during the sentencing hearing and then used it to enhance his sentence, and then later saying we were wrong, we should not have done that, but not reducing the sentence, it reduces the public's confidence in the court system. Because if you say common sense would dictate, and I realize that sometimes common sense and the law do not necessarily run hand in hand, but by saying that we find that you're guilty of this enhancement factor, so we're going to sentence you to X, but then coming back later and saying, no, we were wrong, that enhancement factor does not apply, but not reducing the sentence in any way, we believe sends the wrong signal, Your Honor. We believe it's not proper.
I don't disagree with your logic, but I'm afraid State versus Buys disagrees with that proposition.
Yes, sir. I understand, Your Honor, what you're saying. Our problem is in this particular case, Your Honor, is that it's hard to say that the sentencing in this particular case was fair fundamentally, because if I say to you, Your Honor, or the court, that I'm going to sentence you to this sentence because that applies, and then I say it does not apply, then where is the fundamental fairness in that sentence?
I don't understand that. Are there other things that were said or done in the sentencing that you think, other than enhancement number 9, that you feel were contrary to the purposes and principles of the Sentencing Act?
No, Your Honor, other than I believe that the next issue that we had was not sentencing him to alternative sentencing, given the sentence report, giving all the factors that should be considered. We believe that he was a proper candidate for alternative sentencing and that the court erred by not doing that. That's one of the issues that I've submitted to the court.
And the impact on the child, as you said earlier.
Yes, sir. Yes, Your Honor.
All right, go ahead. Thank you.
The next issue, as I just said, was that he did not get sentenced to alternative sentencing. It appears that the court should have considered, in conducting the review of the sentence, the court must consider any evidence received at the trial and or sentencing hearing. The pre-sentence report. The pre-sentence report, I believe, was productive for the appellant in that they found that he had no previous crimes. He had 0 previous crimes. He had like 3 speeding tickets, but no other previous crimes that were committed by him. Also, the report states that the chances of him reoffending, he was low on the scale, that the chances of him reoffending would be low. There was nothing that was said about the potential for rehabilitation for him. Of course, we believe that the potential was great for the appellant in this particular case because he'd never been convicted of any other crime. He was convicted of a misdemeanor. Alternative sentencing, such as probation, would have been, we believe, Your Honor, a correct sentence for him, and that it would have been rehabilitative in nature. And there's no evidence that it would not have been, because he'd never been on probation before, obviously, because he had never been convicted of any crime. So while we understand that the sentence for, while we understand that the sentence can be anything from 0 to 11 months and 29 days, we still believe that the sentence was not fundamentally fair, again, because even though he had not been convicted of any other crimes, that was not taken into effect. I think the court's only thing that they stated in the record that kept them from that was the fact that they believed that it would lessen the severity of the offense and not put the proper amount of weight on the sentencing on the charge itself. But we believe that the court erred by not sentencing him to that. He was working at the time of the sentencing. He had license to be a licensed firefighter and EMT, and quite frankly, had been working at that when he was arrested and charged with this crime, and they had released him because of it. But he was productive in society, no prior criminal history, nothing that would indicate that he was not a good candidate for rehabilitation, Your Honor. So, and then our last issue, Your Honor, was we believe the trial court erred in finding that the weight of the evidence at trial was sufficient to convict the appellant for the crime for which he was convicted. Quite frankly, on that, Your Honor, we just depend on the weight of the record in that. But the other issues are the ones that we believe should have been. We're asking the court to overturn the sentence in this and the trial.
All right, sir. Thank you.
Thank
you. On behalf of the state.
Good afternoon. May it please the court. Catherine Decker, representing the state of Tennessee. The defendant is not entitled to relief on any of the 5 issues he raises. The facts are very relevant here to understand the sentence and the sufficiency challenge. So the testimony establishes that driving home in the defendant's truck one night, the defendant and his wife, who's the victim in this case, began to argue over the defendant's infidelity. The defendant stopped his truck, and the victim said she was going to get out and walk the rest of the way home. She opened the door and got one leg out. She reached one hand back into the truck to get her purse. The defendant grabbed her hand. He then accelerated and dragged her down the road. She screamed, but the defendant held on. She eventually fell and lay in the middle of the road, and she was unable to move her right arm. The defendant then backed his truck up and got out, angry and swearing at her. She was crying, and she said she was really hurt and needed help. But instead of helping her, he jerked her up by the very arm that she couldn't move and yanked her back into the truck. She tried to call 911, but he slapped her phone out of her hand. She was bleeding, and she told the defendant that she needed an ambulance. But the defendant instead drove to their house. He then went inside himself to leave the victim in the car to get inside on her own. The victim's mother lived with them, and when the victim's mother saw the victim, she cried. The victim's stomach was openly bleeding from her wounds. Her legs were bleeding. They were bruised and swelling. She had holes in both knees, her blue jeans and the skin of her knees. Her feet were bleeding, and her shoes were shredded. The victim's mother took her to the hospital, while the victim stood at the house swearing at them. As a result of the dragging, the victim broke her right collarbone, requiring surgery to insert a metal plate. She wore a brace for 6 weeks. Her collarbone gave her constant pain, and at the time of the trial, she was facing a second surgery that would involve a bone graft. Additionally, she had residual pain in her right leg from permanent nerve damage. Her leg remained swollen, and she could not feel half of her knee. The defendant was convicted of reckless endangerment. Apparently, the trial court meant to instruct the jury on felony reckless endangerment, but forgot to include the instruction regarding a deadly weapon. So instead, he was convicted only of misdemeanor reckless endangerment.
Mr. Powell, you might want to mute your microphone in case there's any kind of background noise or something going on where you are. If you look on the lower part of your screen to the left.
Yes, sir. What am I doing, Your Honor? I'm sorry. I'm not
Muting your microphone.
Oh, okay.
There you go.
So at the sentencing hearing and in the pre-sentence report, the court heard about several incidents of past acts of domestic violence and threats against the victim. And the court also heard about actions that the defendant had, acts of violence the defendant had taken on one of her sons, her younger son, Trent, as well. The trial court sentenced the defendant to 11 months, 29 days, and then has allowed the defendant to spend half of that time on probation after serving 180 days in jail. So now he complains about his sentence and the sufficiency of the evidence for misdemeanor reckless endangerment. So I'll just quickly go through the first three issues and then focus on the sentence in issue 4. As to issue 1, which is the complaint not about considering the evidence concerning Trent, but merely about admitting it. The trial court found it admissible to consider as relevant to his character. But the trial court in sentencing expressly said it did not consider the effect of the defendant's actions on Trent. The trial court expressly said that it considered only the defendant's actions. So that's issue number 1. On issue number 2, concerning enhancements factor number 9, the defendant asserts that because the jury did not find that he used a deadly weapon, that the trial court could not find enhancement number 9, but that's just not true. If you look at the Winfield case that I've cited on page 27 of my brief, the court allows for a trial court to find enhancement factor number 9, so long as the evidence is proved beyond a deadly weapon is proved beyond a preponderance of the evidence. And that's obviously what happened here. The use of the truck was clearly a deadly weapon. The jury need not make that finding. Issue number 3, considering enhancement factor number 10. Absolutely, the trial court in the motion for new trial hearing acknowledged that it should not have found enhancement factor number 10. But as Judge Thomas has pointed out, Vise holds that the misapplication of an enhancement factor does not invalidate a sentence. And in this case, it's not even a situation where this court has found that the trial court shouldn't have found a certain enhancement factor. In this case, the trial court itself acknowledged that it shouldn't have, and we know what the trial court would have done because in the motion for new trial hearing, the trial court went on to affirm the sentence. So we know that even though the trial court knew it shouldn't have applied enhancement factor number 10, that still it considered all the other factors and evidence to support the sentence. So turning to the main challenge to the sentence, the trial court expressly stated that considered all the sentencing principles and enhancement and mitigating factors and all the factors that it was supposed to consider. That's not an issue that the defendant raises. And then it properly ordered split confinement. First, on the basis of enhancement factor number 9, that the defendant used a deadly weapon. And second, it ordered split confinement. It found that split confinement was necessary to avoid depreciating the seriousness of the offense. And here, the trial court noted that the victim's injuries were horrendous. The trial court noted she had permanent scars where she lost skin on chest and legs. And you can see these in photographs that were introduced at trial. She had a broken collarbone requiring 2 surgeries, permanent nerve damage, pain, and numbness to one of her legs. Those are the victim's injuries. The trial court went on to find that the offense was rendered particularly egregious due to the fact that the defendant possessed an emergency responder medical license. In fact, he had worked as a firefighter. The defendant would have known that the victim was badly injured. She screamed. She couldn't use her right arm. She was bleeding. She requested help and an ambulance. And yet he did not help her. In fact, he laughed at her, swore at her, threatened her, blamed her, and manhandled her. And the trial court properly considered that as egregious. The court properly considered as well that confinement was appropriate to provide effective deterrence to others. And here the trial court mentions, the common issue of, or commonly known problem of domestic violence in the country. And of course, in this instance, we have this particular instance of domestic violence and evidence in the pre-sentence report and in her testimony at sentencing that there are multiple previous incidents. And so deterrent is clearly properly considered. Finally, we have the court finding that the defendant was not truthful during the trial when he claimed that he did not drag the victim. The court made an express credibility finding about that, and the trial court can consider a defendant's untruthfulness in deciding whether to grant him full probation. So on that basis, the sentence was certainly proper. The defense puts forth some evidence that was in the pre-sentence investigation report that he was gainfully employed, he had no risk of, he had a low risk of reoffending. These were considered by the court, of course, because the court considered the report. And so this is really an argument that the court should have weighed this evidence differently, but it's in the trial court's discretion to weigh all the evidence in enhancement and mitigating factors, however the court, in its discretion, wishes to weigh those. It's not for this court to reweigh those. So for those reasons, the trial court sentencing decision should be affirmed. And finally, about the sufficiency of the evidence, I'll just rely on my brief for the analysis and also on the facts that properly viewed in the light most favorable to the verdict certainly support the defendant's conviction.
Thank you. Mr. Powell, you have 5 minutes of rebuttal time if you want to.
I don't think that it will take that long, Your Honor. Quite frankly, I just want to refer back to my brief, and under the enhancement factor that was used, number 9, I would refer back to Tennessee Code Annotated 40-35-114, which states that enhancement factors must be appropriate for the offense and not themselves essential elements of the offense. And in this particular case, by finding that he had used a deadly weapon, they made it an essential element of the offense, because that is the difference in felony reckless endangerment and misdemeanor reckless endangerment, is the use of a deadly weapon. And by not finding that, and by finding that enhancement factor to be correct, then it would have been an element of the crime. And we submit that that was improper, Your Honor. We would just say, Your Honor, that there was a lot of talk at trial and some talk today of domestic violence. My client was not found guilty of any kind of domestic violence. He was found guilty of reckless endangerment of misdemeanor. The trial court did not find him guilty of any type of domestic violence issue, but they used that heavily in their arguments in the trial court and today that the sentencing was appropriate. We believe that testimony was part of my original issue about what was being allowed to inflame the court in the sentencing hearing. We just like the court to consider all the arguments we've made today, and we appreciate your time.
Thank you very much. Appreciate your all's arguments. Mr. Clerk, if you would put us in recess for a while.
This honorable court is now in recess until 3 p.m.
Thank you.
Thank you.